Martina Ken, and we're now recording. I'm welcoming you here, and I'm very excited about this particular moment because it's really important that we really think about estate planning and the fact that you've taken the time tonight to really think about how you can make a difference in this community with regard to taking the next step forward. The Virgin Islands Economic Development Authority is the economic development arm, one of the main ones of the Virgin Islands, the U.S. Virgin Islands. We step forward to try to grow our economy in the most positive way. The Enterprise Zone Commission, the unit that is putting on this particular conference, is the community development and the public sector community development arm. Our goal is to revitalize once vital, vibrant communities that are now considered distressed. One of the reasons it's considered distressed is because, unfortunately, there are a lot of properties within these communities that are owned by multiple people in multiple generations. Think about a great-great-grandfather, his wife, and children. And let's say they had 10 children, which was average or normal time period. And 3 or 4 of those children left the territory never to return. Their fondness for the territory never left them, but they never returned to this territory. And they had lots of children, right? They had children, grandchildren, great-grandchildren. Some of them have never heard of the Virgin Islands and have no idea, right, that their great-grandmother owned property here in the territory. She and her husband. And the first thing they did was buy property. Imagine, as my grandmother would have said, they're rolling in the grave, right? Because they did this, they strived, they worked hard to put this together. As you travel through the territory, I want you to really think about when you see buildings, why they're in the condition they're in. It is not, and I want to make this clear, it is not that people have not stepped forward to say, I own 1/63 of this particular building, right? But they have enough money maybe to pay the property taxes, but not enough money to fix it. They can't get a loan because you don't have ownership, right? We have held estate planning conferences before. And in all honesty, my team and I decided to stop because we didn't see action being taken on behalf of the people of the territory. We stepped forward again, this time in a multimedia way, to get to as many people as possible, even in this time of COVID, so that we can get the word out. Imagine the potential for legislation to come and take that piece of property away from you. So we want to think about that, right? Tonight, we have 2 legal counsels that will step forward to discuss various different components of how you can prevent this from happening, or how you can sort of extricate yourself from this challenge that we're facing now. We have attorney Anthony Couture out of the island of St. Croix, and he'll be talking about probate. And we have attorney Anna Paiwanski out of the island of St. Thomas, and we'll be talking about trust versus doing a will. Before that, I'd like to introduce my team members. On the island of St. Croix, I have Mr. Raheem Smith, Enterprise Zone Specialist out of the island of St. Thomas, but he's on St. Croix today. And also on the island of St. Croix, Mr. Wayne Scott Jr. Is the Enterprise Zone Specialist for the island of St. Croix. With me today is Ms. Shayla Anthony. She is our compliance specialist. She also works on grants and compliance for grants. This conference and the activities that will happen after this conference is sponsored by the Department of the Interior. And so we thank them for stepping forward and giving us the funding to really work towards resolving this problem in a real way. It is multimedia, and we're going to spend a lot of time working with all the individuals on Zoom and in the locations to answer questions. We're going to spend more time on that than actually the presentations, right? If you have a question and you're watching this or listening on the radio, or watching this on television, we ask that you call. If you have a question, call 779-1079. And that question will be fed in, and we will ask during the question and answer period of our counsels. But let's be clear. Those legal counsels are not here this evening to provide legal advice. They are not here to provide legal advice. In fact, they are here to provide information. Okay? So you can't go and say, okay, this attorney said this is the case and you have to do this. No. They are here to provide information that you can take back with you and say, okay, I need to look at this. I need to think about that, right? And then you could go and hire a legal counsel to assist you. Here's how we're going to do it. We're going to have a presentation first from Attorney Couture on the island of St. Croix, and then a presentation from Attorney Paiwanski here on the island of St. Thomas, and then we will open it for questions. Okay, there are in the rooms, if you're here in person, refreshments. I encourage you to go and grab things to drink and eat. For those of you who decided to do by Zoom, of course, you're more than really happy to go ahead and raid your own refrigerators this evening. But we just want you to be comfortable. We want you to really take in the information and send your questions. We really are going to spend time with your questions. So without further ado, I'd like to introduce Attorney Anthony Couture. Attorney Couture has been in private practice of law in the United States Virgin Islands since 2006. He has both a Bachelor of Arts in Business Administration and a Master's of Business Administration from the University of the Virgin Islands, and a Juris Doctorate from Western Michigan University, Thomas M. Cooley School of Law in 2005. Attorney Couture manages the Couture Law Firm, where he is managing attorney of a firm that specializes in estate planning, probates, real estate transactions, litigation, and commercial transactions. And so I'd like to introduce Attorney, we're not seeing him up yet, Attorney Anthony Couture.
Okay, again, let me say good evening again to those present and those who are on the internet and on the radio and television. As Ms. Kim said, I'm Attorney Anthony Couture. Practice in St. Croix, splitting the act. I'm here to give you an overview of the probate process. Let's get an overview. And I will do it in 4 steps. I will define what a probate. We will discuss non-probate assets versus probate assets. Then we'll have a descent and distribution. And then finally, on top of the text are probate petitions. Probate. Basically, probate is the legal process where the estate of a decedent is administered. Whether it's invalid or not. But the house will know And it's very important that a will does not avoid the probate process. Some people are under the conception that I have a will, therefore we go to the probate. But will does not avoid the probate process. Attorney Pewanski will talk more about wills in her presentation. Here's some terms, basic terms. The decedent, that's a person who has died. Okay. Now, if someone died in that stage, that means that person died leaving a last will and testament. The second stage, that means they died without leaving a last will and testament. So be very conscious of the differences. Then I'm going to talk about what are considered non-probate assets and what are considered probate assets. Okay. For non-probate assets, these are assets that are held as joint tenants with a right of ownership, or assets with beneficiary designation, and or assets that have pay and debt or transfer and debt designation. For example, if you have a property and you have that upon your passing, the property should be passed to your son or whatever, that will be a transfer and debt deed. Now, examples would be life insurance policies, 401ks, and again, these are say with the right of survivorship provision, or transfer and debt provision. Now, probate assets. Now, these are assets that are held in your name only, no designation for right of survivorship, no transfer and debt. Just in your name. So therefore, the court has to step in and transfer the right from the decedent to the heirs or the next heirs. And note that if the decedent left a will, a last will and testament, then the beneficiaries that are named in the last will and testament, they will inherit. No last will and testament, then is the next of kin. That's going to be explained when we talk about descent and distribution for next of kin, which is right now. Okay. I'm just going to the basics. So some examples. Married with children. This is the person they're married and they have children. So for their estate, the wife, spouse, for the husband in the case, will be entitled to 1/3 of the deceased estate. And then the remaining will go to the children, 2/3. Okay. Now, for example, the person is married, they don't have any children, but their parents are alive. So, 1/2 goes to the surviving spouse, $5,000 goes to the surviving spouse, and the other half goes to his or her parents. Now, married without children, one parent survivor. Again, 1/2 goes to the surviving spouse, 5,000 to the surviving spouse, and the other half goes to the surviving parent. If no spouse, if no surviving spouse, then everything goes to the parent.
Well, what is the providing spouse?
So the person that lives, okay, the husband died, so therefore the wife will be the surviving spouse.
Yeah, what you mentioned, parents could also get the same thing.
Yes,
Why?
that's the law. If there's no children, the parents are entitled to representation. This attorney Pewanski will explain the trust and estate planning provision that would effectively avoid the probate process. I'm just talking about the law based on the approach to the probate. Now, another example, the individual is married, they have no children, no parent, no siblings, their fees on this. Everything goes to the spouse, right? 100%. However, if there's a sibling or a niece, then half to the spouse, so 10,000, that half to the siblings. Not married, no children, 100% goes to the children. Not married, no children, no parents, 1% distributed to the next of kin. I'm going to explain what it is. And then the type of probate petitions. Okay. First one, talk about testamentary estate. That means the person died with a will, leaving a last will of testament. Now, there is certain things you have to address. We will need the original death certificate. There's a court filing fee, there's a petition. Of course, we need a last will and testament attached to the petition. You will need a consent of the heirs and those who are in the who are named in the will to the probate. You also need an oath of the executor, of the person that is defeated name as executor to administer the will. You need an inventory of the estate by two appraisals. I mean, two individuals. You need put in the newspaper notice to the correct debtors. You know, so you can back in the newspaper, you'll see a probate has been filed open. That's what file notice to the correct debtors. Basically saying, for those individuals who owe the decedent, contact the attorney, and for those who the decedent owes, they can file a claim against the estate. And then in this settlement, you have appointed accountants, and then there's a final accountant, and then there's a final education fee. I'm just going through the basics, just to give you like a basic understanding. Now, there's another probate petition. This is administration of a tested, and this before can tested mean died without a will. So basically, the statement before, you need a death certificate, the filing fee, the probate petition, the consent of waivers and of the heirs. But rather than the oath of the executor, you have oath of the administrator. Then there's letters of administration, the inventory, and appointment of two appraisers, for the accountants, final accountant, and also there's a final application fee. Now, it's not an abstract. The family decide to say, you know something, I'm going to do a technical administration. And what that means is that the family is going to accept the assets along with the debts of the decedent, making itself fully responsible for any expenses or debts that they decedent owes. This one is shorter than the other relative before. But with this one, all of the heirs was consent. So if one person said, I don't want to do it, then you can't do a separate administration. And it had been in this field for at least 4 weeks. Then there's the summary administration, and that affects estates that are under $100,000. And the difference between summary administration and second loan administration is that the publication runs 2 weeks versus 4 weeks. And then the last one would be an ancillary probate. And that means that a non-resident, someone not from the VI, but they own property in the Virgin Islands. So therefore, they are probate in the States, and the family is trying to probate the property in the Virgin Islands, so therefore, that probate. It's called a foreign probate, ancillary probate. And this is just basically, as I said, it was an overview of the probate process. As Ms. King said, we want you to ask questions, like look at your situation, see how your property, how you probably got this title, whether it is joint tenant or it's a fellowship, or whether it does in your name on, whether it is a provision. And then after that, be motivated to do something about it. And I don't, that's it in a nutshell. Okay.
Question.
After. Okay. So, I believe we want to give them come next.
Well, about 4. How many breaks do we do?
You have some information with regard to probates. What we will do for everyone that we went through the slides too fast, we will email that out to you so that you could get a copy of that. For those of you that did not provide your email address, we need your email address so that we can get that out to you, okay? Up next, and I just picked up the wrong documents, so I'm going to do this off the top of my head. Attorney Anna Paiwanski is a graduate of All Saints. She is a daughter of the soil. I want to say 4th generation Virgin Islander. She is, 3rd generation, she is correcting me. 3rd generation Virgin Islander. She has been an attorney for, I left my paperwork, so for a long time. Estate planning is her area. And so without further ado, I'd like to introduce Attorney Anna Paiwanski.
Good evening. Good evening, everyone. I am going to be talking to you about wills, trusts, and estate planning. And we're going to go fairly quickly because we want to get to your questions and answers. So the first thing I want to talk to you about is what's the difference between the wills and trusts. A will conveys property that you have, interest, assets that you have to designated people, but you must go through probate in order to accomplish those transfers. So a will, after you've passed away, the property will go pursuant to your instructions in the will, but you do have to go to court and file a probate petition. A trust, however, is a document that is outside of the court system completely. In that document, you identify as the trustee to begin with, you identify the assets that you have. The trust takes care of you during your lifetime. A will only takes care of you after you've passed. A trust takes care of you during your lifetime. And one of the benefits of having a trust is if you become incapacitated, your successor trustee then takes care of you, takes care of making sure that your WAPA bill is paid, that the lights stay on, that you have water, that your medical needs are taken care of, etc. So that person that you designate as your successor trustee then is sort of like your guardian. They're responsible for taking care of you, but you've picked that person. And I usually recommend that people pick multiple successors in case that person predeceases you. There's someone else behind them that will be able to pick up and take care of you during your lifetime. After you've passed, that successor trustee who is responsible for distributing the assets as you have designated. And so if you have a piece of property and you specify to whom that property goes, or if you have multiple children, what you do is you designate that the property, for example, can be sold and the proceeds from that sale can go to your multiple children. So that is essentially the benefit of having the trust is you avoid the probate process and you designate who you want things to go to. And what you can also do within the trust is you can specify that if that beneficiary predeceases you, you can name another person who is going to benefit from that asset, whether it's a bank account, a vehicle, a piece of jewelry, whatever it is. So those are the differences. And I think I've already just explained why you should have one, because you do want to avoid the probate process. And you can also change your trust. It's not written in stone until after you pass. Once you pass, it becomes irrevocable. But while you're still alive, you can make changes to it. And you can change a will as well. You can revise it as you wish. But a trust is not set in stone, so you have the flexibility. And if somebody does predecease you, you can name somebody. If somebody does something you don't like, you can write them out and put somebody else in the place. Now, for people who are born in the Virgin Islands or naturalized in the Virgin Islands, there are tax benefits for you having property transferred to your children because they inherit tax-free. Important to know if that is within your category. And there are some things that can be done with respect to assets that are owned. If your spouse is not a naturalized or Virgin Islander, then a lot of times we recommend that you put those assets in the person's name who is the Virgin Islander so that the children inherit tax-free. Revocable and irrevocable. As I mentioned earlier, revocable, you get to change it. If it's irrevocable, it's set in stone. Now, the revocable trust will become irrevocable at the time that you pass. There are circumstances in which you would create an irrevocable trust so that it can't be removed for debt purposes, collection purposes. It stays within that structure. So there's a little bit of more protection there, but it's not flexible. You can't change things as easily in an irrevocable trust. What should you put in your trust? I tell people to put everything in the kitchen sink into the trust, because Granny Sugar Bowl that you don't think is worth very much is going to become the thing everybody fights over when it comes time to deal with your estate. And if you don't put Granny Sugar Bowl in there somewhere, somehow, whether it's all of my dishes or all of my fixtures and furnishings, then somebody who wants to create confusion can go to court and say Granny Sugar Bowl is not in the trust. And the next thing you know, you are spending the assets, or your beneficiaries are stuck spending the assets of the estate probating Granny Sugar Bowl instead of distributing the assets where they should go. So there really isn't anything that shouldn't go into the trust. If it's got value or you think it may have value, identify it and provide who the beneficiary should be. And a trust there is no limit in terms of what can be in the trust. You live here, but if you own a piece of property in Trinidad, you put that piece of property in Trinidad in that trust. There's a way to do that. It's one document that covers everything you own. So it's not like you have to have a trust in each place that you own property. What decisions do you have to make? The initial trustee is normally yourself. That's because you have the skill and well-being to take care of yourself, pay your own bills, and do your own thing. So you don't need anybody to do that for you yet. When you get to the point in time where you do need help, then that's when the successor trustee steps in, okay? So generally speaking, you're the initial trustee. And the successor trustees, it's very important when you're picking a successor trustee to pick somebody who, remember, they're going to be making decisions for you during your lifetime. You want them to look out for your best interest. You don't want them putting you in a nursing home when what you really want is to be in your own home. So think about who it is that's actually going to carry out your wishes and do what you want for your best interest, and not necessarily think about, well, if I skimp here and I skimp there, then that means there's more for me later. You want the person to think about you and take care of you during your lifetime. After that, you can explain who gets what. But these are important decisions, who you identify as the successor, and choose wisely. Who is going to care for you? Now, in addition to having your successor trustee, what you also have are people that you give power to, general powers of attorney and medical powers of attorney. So it's important to identify who can go to the bank and take money out, who can go and pay these bills that need to be paid. That's one set of questions that you want to identify people for. But the other set of questions is, if you're incapacitated, who is going to make the decisions at the doctor's office or at the hospital about whether you do or you don't get a particular medical procedure? Now, there's certain documents that are normally done in estate planning that you control by saying, if I have these conditions, leave me alone, or do everything you can. However you personally want to be treated for those medical issues. But you have to keep in mind that there is a possibility that you may not be able to make those decisions because of your condition. And so you want people who can make those decisions for you and that you trust that are going to carry out what you want. Again, not what they want. They may want to keep you around until they come up with the solution for this particular condition, and you may not want to be here for the next umpteen years on a machine. So these are important things for you to think about in terms of how you want to be cared for, because remember, the doctors will do everything they can. They are legally required to do everything they can to keep you alive. So if you don't give them instructions, that's what they will keep doing. The other decision you have to make is who's going to get what. And most of our families in the territory are not single children families. We have multiple children. And many people have come to me in the past and said, well, I don't want to pick one of my children to get this piece of property. I want them all to keep it in the family, and I want it to stay in the family for years to come. And I hear this all the time. And I think to myself, okay, all we're doing is creating a nightmare, because that means that property is going to end up in a probate action or a partition action in court, again, eating up resources, because you can't divide that property. If we're talking about 50 acres on the north side that haven't been developed, great, go ahead. You can divide them up and you can give all of them each an acre. Great. But most of the time, we're not talking about that. We're talking about what Ms. Marchena was talking about, these 2-bedroom homes that you can't divide amongst 5 people. There's no way. And ultimately what happens is, if you put all of this property in the name of 5 children, generally speaking, one child, and I've seen this too many times, one child ends up carrying the bag and has to pay the taxes and do the maintenance and the repairs and everything else. And this one up in the States and this one down island and that one over there, they don't have money, they don't have this, but they all have an interest. And so it makes it very challenging. And then one day that person who's been carrying the load is going to get fed up and say, not anymore. And then this property is going to turn into disrepair. And that is what this is trying to accomplish, to avoid those situations. So what I tell people, generally speaking, is pick one person. If you can't pick one person, have the property sold, divide up the proceeds. If you don't like that solution, come up with something that can work. Maybe the property is owned collectively, but there's a way that it's managed and everybody has obligations. But it's very tricky. And I try to get people not to transfer property to more than one person because you end up in headaches, lots of headaches. The other thing too, as I said before, is somebody may not survive you. So if you designate that you want, Granny's wedding ring to go to Mary, and then Mary predeceases you, you should name somebody to come behind Mary. Otherwise, there's going to be a fight over who gets Granny's wedding ring. So think about this in terms of who do you want to have these things, and it's easier to designate who the successor trustee is supposed to give things to, instead of just saying, these are all in my trust and you all figure it out when I'm gone. Because the person who's in charge of doing this, and trust me, I've dealt with the people who get left with the document and all the instructions. The more instructions you give them, the easier it is. If they have to figure out what you wanted, it is agonizing for them because they want to do what you wanted, but you don't give them enough instructions. So, divide it up. It's up to you how you divide it. There is no basis for anybody to come back and say, mommy didn't give me this. Mommy should have given me that. Or daddy should have given me that. And he promised this to me, or somebody said I was going to get this. If the trust says it goes to your sister, then it goes to your sister. That's the end of it. Okay, per stirpes. It's a legal term, Latin term. It means bilineal descent. So if you have children and you've transferred the benefit to those children, but they predecease you, but they themselves have children, they're your grandchildren, and you don't want your grandchildren not to get your child's portion, you say per stirpes. That means that from you to your children, to your children's children, they will get their parents' portion. Okay, if you don't do that, then it goes to their siblings. You follow me? So if you want, in some cases, there aren't grandchildren. You might have one child who has children and one child who doesn't. And in those circumstances, until that person has a child, you may want those benefits to go across to their sibling and then down to the other beneficiaries. At some point in time, if they have children, you can amend it and include their children, or you simply say per stirpes. But if they don't have children, then you say to whom that goes. And there are situations where people don't want it to go to any of their children because they're already fed up with them, and they want it to go to the Humane Society or the church or someplace else, and that's fine too. It's whatever you want. Okay. The best way to make sure that everything is in your trust is to put it there. So when you want to put property in a trust, you actually have to transfer the property from your name to the name of the trust. If you have a vehicle, I recommend to people, transfer it to the trust. Don't just say in the trust, it goes to this trust. Transfer it into the trust so that it's there. There's things that you have that you can't obviously transfer. I mean, you could do a bill of sale, but jewelry, you just take a picture. This is the best, easiest way. You take a picture, you put it in the trust. I tell people, look around your house, take pictures of all of the artwork, the jewelry, whatever you have. Those are the things that you identify who gets what. Picture paints 1,000 words. It's the easiest way to do it, right? Take pictures and say who gets what. Very simple. And don't forget Granny's Sugar Bowl. Once you have a trust, you want to review it at least every 5 years to make sure that nothing has changed. It's not such a big deal that you sold that car and you don't own it anymore. The important thing is that the new car you got in its place is acquired in the name of the trust. Everything you get after the trust is created goes to the trust. And then it's very simple. You can do these one-page addendums that says, now I have this car and this car goes to so-and-so. The fact that the other car is sold isn't such a big deal, but if you want to keep it clean, you can say this car was sold. Now I have this car goes to so-and-so. If a property gets sold, then you say the property's been removed. When you do sort of a review and just sort of clean things up so that the successor trustee isn't chasing down assets that you don't own, because that's just a waste of time. So if you already got rid of it and you do a revision every 5 years or so and just clean up and say, okay, I sold this, I got rid of that, I gave this away, you take those things off the list. Okay. Speedy, we did it. Thank you.
Thank you so much, Attorney Paiwanski. In order to make up some time, we're going to start fielding questions. Can you see me from this point? I have to stand in the center. We're going to start fielding questions from the community. And we're going to start in the St. Thomas district. You have a question, sir? Please rise, or at least take off your mask for the minute. All right, so that's a general question. You already have all your assets in an LLC. How does that work with a trust?
Very simple. So you take the membership certificate that's in your name, you cancel that certificate, you issue a new certificate under the name of your trust, and you transfer what was yours from you to your trust.
Repeat that for me, please.
So if you have a company, a corporation, or a limited liability company, either way, if you have a limited liability company, it's membership certificates. If you have a corporation, it's shares of stock. So you have that certificate, you transfer on the document itself. And if you don't have membership certificates, you should get a company kit because it comes with it. It's very easy. It comes with a seal and everything, and that's where you put all your company records. But it has certificates. So you have the certificate in your name for however many membership units or shares you have. You transfer it to the trust and you cancel your certificate, and now it's in the trust and the trust owns it. You're welcome. Thank you.
Okay, oh, I'm off camera, sorry. Okay. Are there any questions from St. Croix right now? Are we going to Zoom, Facebook? I hear there's lots of you there. I had one question that came in.
The question was that if to do it with challenge, if we people leave out a child from the will, if that child can challenge the will, and look, the response is yes.
I'll do the short answer because I am not a legal counsel. I'm not a legal counsel. But I just want to repeat some of the things that Attorney Couture said. I'm going to do it in 2 sentences because he gave a lot of legal information that I can't. The question was, in a will, if you leave a child out, can they challenge the will? The answer is yes. Really, they can challenge the will. But he indicated that in a trust, it's speaking from the grave, right? You can do it in a trust, you cannot do it in a will. The will can be challenged. Is that correct, Attorney Couture? That's what you said?
Anyone can contest the will. Anyone can say, I should have gotten more. So a will is not clearly. Okay.
Okay, I'm going to go to a question from,
1 second.
okay.
So what he's saying is, if you didn't hear, that the person can contest the will. Normally what people will put in the will is to say, I did not provide for Joey because I provided for Joey during his lifetime. He can still contest it. Ultimately, the judge is going to decide whether or not what you said about providing for him was more than sufficient. But there are many situations in which you provide for your child during their lifetime, support them well beyond their young years into their adulthood, and you've done more than you plan to do. So you can certainly put that in, yes.
Hold on 1 second. I have a question from Facebook. Oh, this is Zoom. Can I put my house in a trust if I have a mortgage on it?
Yes, you can. You just need to notify the lender that you have put the property in trust. They probably will ask for a copy of some trust documents, but the mortgage runs with the property. As long as the mortgage is on the property, it doesn't matter what you do, that mortgage is still good. So you can do that. I generally recommend that you notify the lender. They're protected because they have first priority, but notify them so that it doesn't look like you're trying to pull a fast one. But yes, it's still going to be a valid mortgage and you haven't avoided the mortgage by putting it in your trust. But yes, you can do that.
Okay, and another question, if you have a trust, how do you add new property?
Very simple. You get the property in the name of the trust. Do not get it in your own name. You're just creating more steps. So what you do is you get the property in the name of the trust, and it is then trust property.
Coming back to the will, right, with a child left out, can that be done in a trust also?
Yes, you can leave all your children out in a trust and give it to the church. That's not a problem. You can do whatever you want to with it, with a trust. Yes, anything.
Excuse me, Ms. Ken, there's a question in St. Croix.
Yes, please go ahead.
Would be for Attorney Powanski. The question was transferring property to a trust from a foreign land or foreign country or from the States. How to do it?
How to transfer property if you're here and your property is someplace else.
Oh, what you do is you take the deed that you have already, however that deed is drafted. You basically use the same form or format because in every different place, they have a different way of drafting the deed. You use that as your template. And instead of your name, you substitute the name of the trust. In some states, it's very simple to do because you go online to that state and you get all of the recording instructions for how much it is, and you drop it in the mail and they send you a date stamp copy back along with it, all the paperwork. But that's part of the process. And so if it's a piece of property in Tortola, you would fill it out, you know, the way deeds are drafted in Tortola, and you would get it to Tortola and record it according to their procedure. But it's all part of the same process.
There's a Facebook question for Attorney Couture. Could you please repeat the types of probates?
Okay, there's administration of a tested estate, administration of an intestate estate, settlement without administration, summary administration, and ancillary probate.
There is a question that came in that indicates, is there a list of probate attorneys in the Virgin Islands? And the answer is yes. You can go to the Bar Association's website. There's a more specific question here that says, can we have the numbers of the attorneys that are presented this evening? What I will do is, with their permission, I will email those numbers to you so that you can get more information directly from those attorneys on a private consult, okay? Is that okay for everyone? It came in on Facebook, so I take it that's a yes. They asked a question about life insurance on a mortgage. Should I add the life insurance to the trust? Can you add life insurance to the trust? I guess, yes,
What you
because,
said on the mortgage. So
yeah,
that's
but they said on a
confusing.
mortgage, I don't understand that one. I have life insurance on my mortgage. It means they have, it should have insurance on your mortgage, but let's say they're just saying life insurance and a mortgage. But
Okay, two separate things. So
Right.
if you have insurance on your property and you transfer the property to your trust, you're going to want to transfer the insurance coverage. Again, just like you would do with the mortgage, you notify the insurance company that you've transferred the property to your trust, and they will make the trust the named insured at that point. So that's a very important point to make, both for mortgages and for insurance. If you have a life insurance policy, you do need to contact the life insurance carrier to confirm with them that you can make the trust a beneficiary. Some life insurance policies will let you and some will not. Generally speaking, what you do on your life insurance policy is you name your beneficiaries. And in most cases that works, but what happens if they predecease you? Then you want a fallback because you don't want that to end up in probate, and it would end up in probate if you don't have a living survivor. So if you can name the trust as another beneficiary down the line after your children or whomever you're naming, then it would go to the trust, and the trust would say, if all of these people predecease me, then it goes to wherever it goes, whether it's a best friend or a church or a nonprofit organization, but it goes somewhere. So in some instances, you may just want to name the trust as the beneficiary and then let the trust dictate what happens and how it gets divided. Some of these insurance companies, however, don't recognize that. So you would just have to keep naming people. After your children, you name your nieces and nephews and your cousins and whatever until you get to the end.
another question. If your parents' house was in a life estate to their children, but the parent died without a will, what does that mean and what should you do?
If I'm understanding the question correctly, and Attorney Couture can jump in as well. If the property is in a life estate, that means the parents had it as a life interest and then it goes to their children. So then however many children they have now become the collective owners in equal proportion. So if there's 4 children, they all own it 1/4 each. And that's when all the headaches begin.
Exactly. Exactly. What some individuals like to do is they will transfer the property to the children, but they will hold a life estate in their life so that they die to the children. But attorney once we said, if it's 4, 5, 6, 10 children, what's going to happen when the parents die? Then it's been owned by multiple parties, and that could be a headache. I have a question from St. Croix, and this will be for Attorney Permansky, and it was in reference to trust and investment, if they could be in a trust.
Can an investment be in a trust?
Yes, what kind of investment, like a money market investment?
Okay, she said yes, money market investment.
Yes, so you would have beneficiaries on those as well. And it's just like the life insurance policy, you need to contact that investment company to find out what forms they have, because each one has their own special document that does this. And then make sure that the people or the trust that's identified, and that they will recognize the trust if you want to name the trust. If not, you have to keep naming successor beneficiaries.
What you could do is do the provision, like who's gonna take care of the animals. And they ask about the cost. And for my response would be you to contact your attorney, because everybody trust is different and there's different prices. So I would not give a rate and say it's gonna cost X dollar or what. But I know Attorney Pawanski, if you agree with me.
I'm going to,
I
I'm
love
going
it.
to interrupt and say that generally wills are less expensive than trusts, but each attorney is different, and how prepared you are before you go to your attorney is important. And that's all we're going to say about cost today.
Well, no, this is actually one of my favorite questions, because I want to tell all of you this. If you go to an attorney and they ask you the value of your estate, and they determine the cost of doing a trust based on the value of your estate, leave. Leave. If you go to an attorney with all of your paperwork on your accounts and your properties and your assets, and they say, well, approximately how much is this worth? Or that they're going to bill you based on the value of your estate, pick up your stuff and run, because it has nothing to do with the value of your estate. If you have multiple properties, obviously it's going to cost more because you have to do deeds for those properties. But we're not talking huge amounts of money. Whether the property is worth $50,000 or $1 million, it's the exact same amount of effort to draft a deed. It's just a couple extra zeros typing in. The deed itself is identical regardless of the value. So don't let anybody choke you by charging you based on the value of a piece of property. Generally speaking, depending on what you have, because obviously the more things you have, the more stuff you have to distribute. Okay, so that just means the document gets a little bit longer. So I would say there's a range of probably between $2,000 and $5,000 to get it resolved. Generally speaking, could be a little bit less, could be a little bit more, depending on what's in there. One thing I do want to comment on, though, with respect to properties, there are a number of people who have come up with this way to resolve probate and avoid all of this expense of having a trust by putting the property in the name of you and your children. The idea being then, well, if it's in your name and the name of the children and it's right of survivorship, meaning whoever survives, then you don't have to go to probate. But this is the problem. If that piece of property then is needed for your care and well-being during your lifetime, and you put that property in the name of someone other than yourself, you will never be able to encumber or sell that property in order to be able to take care of yourself, because those other people are going to have to agree. So what I tell people is what's yours is yours during your lifetime. They can enjoy it when you're gone, but during your lifetime, you get to decide. And so as much as they have promoted this concept as being the easy solution has setbacks. And I don't know about you, but for the most part, I don't have the resources to be able to give away property. And I don't have the crystal ball to say, what am I going to need for the next 50 years? So I might need that asset. I might need to mortgage that asset. I might need to sell that asset and move into something smaller, or go live with a relative, whatever, or go into a home that can take care of me for my special needs. But if I can't afford that because this piece of property that was mine is now mine and other people's, I'm not going to have that luxury. So just keep that in mind. It sounds good, but I question whether it's really so good. If you have a phenomenal relationship with your children, and then remember, after you go, if you have more than one child and that property is in their names, let the fights begin, because that's the whole melee that you're going to end up with when they end up with the property. And even the people whose children got along well during their lifetime, when you're gone, trust me, ain't the same thing.
So we want to repeat this. So you have 3 children and you get sick and you pass. Those children may have gotten along in life, but with death comes challenges sometimes, right? The oldest child may indicate that, is this on? Yes. The oldest child may indicate that they're the eldest. They were the firstborn, and so they're the most deserving. Your middle child might say, you know what? I am the one that was there every day taking care of mommy and daddy. I clean, I wipe, I cooked, I did everything. I went to doctors day in and day out for mommy. And the youngest one would say, well, my parents take care of me all the time that I was growing up. I am their baby. And so now you think, oh, well, you know, they have gotten along, but now you've caused a problem and a challenge. So it's important to solve the issue, right? Deal with it in the front end. There's a question that came in, Attorney Paiwanski. Should a husband and wife get a joint trust, or should they get separate trusts? Especially if there is outside children or involved.
Who tell you say that?
Right, I had a question.
Okay, let me just say that it really honestly depends, okay? If you're in the Virgin Islands, you were born in the Virgin Islands, or you were naturalized in the Virgin Islands, your children are going to inherit tax-free. Generally speaking, if you are of a certain economic stature that the two of you together combined assets could create a situation in which the value of the trust creates a tax situation, then you would do 2 separate ones. Another example, if you have somebody who's born in the Virgin Islands or naturalized in the Virgin Islands and their spouse is not, there are certain things that we do that make sure that the Virgin Islands property is within the ownership of the Virgin Islander, and then other assets would be in a separate trust with the spouse who is not a Virgin Islander, again, not to create tax issues, okay? It's a complicated question though. It's not a straightforward do this or do that. So it's not something you have to actually on a case-by-case basis sit down. You may need an accountant to tell you what the tax implications are. And if there are situations in which there are children from prior marriages or what have you, they can be dealt with in the same trust, okay? But there may be circumstances in which it makes sense to have 2 for tax purposes. Now, you may also have a situation in which one person has a business that one spouse has a business that's connected to that spouse, and they want it to go to their children and not to their wife. They may have two separate trusts because of that. The trust can take care of the spouse during their lifetime, but the benefit of it would go to their children. So it's a case-by-case basis. It's not something that can be just simply yes or no.
A question, please. Should I go ahead?
Please do.
Okay, the question is, let's assume that somebody as a young man fathered 2 children, and the gentleman was not married, the lady was not married. In later years, the gentleman became married and had a child as a result of that. So you had 2 prior children, and now you have a child in wedlock. You mentioned, let's assume the children, the first 2 children were born in the Virgin Islands. And when you say Virgin Islands, you have US and you have British. And the lady that the gentleman married in later years had children, so now you have stepchildren. In general, what are the rights of the children that were born before the marriage? Obviously, one could argue the right of the child that was born as a result of the marriage. And what are the rights, if any, of the children, the stepchildren, if any? I don't know.
For the deceased, his children, whether born before, out of wedlock, during his marriage, they have 10 children with 10 different women. They're all his children, so all are entitled to his estate. Simple as that.
I guess that's in the US Virgin Islands. In the British Virgin Islands, it might be a little different.
Okay. I'm talking about the US Virgin Islands, the US law.
Okay.
I'm not talking.
And
So,
the stepchildren don't have any rights, do they?
We're talking about, no, the stepchildren don't have the rights, but his children that he recognized, the children that he recognized as his children, he signed a birth certificate. In addition,
Right.
even if he didn't sign a birth certificate, they could come back later in life and establish paternity and say, this was my father. They could do DNA tests to establish that they were in fact the offspring of this individual.
So the question is, what's the process for setting up a trust?
They want to know who will make sure that the assets are distributed according to the individual of the trust.
Well,
You got it?
the attorney who drafts the trust is the person who should be making sure that it gets properly executed, and that the assets that are supposed to go into the trust get into the trust. So there's usually a signing ceremony where everything gets signed off on. The other thing that I wanted to mention is normally what we do when we set up a trust is we set up what we call a pour over will, which basically says, if I left anything out, or if I inherited something that I didn't know I inherited because I got it afterwards, it goes to the trust. It's a much more simple document than a traditional will, but it's called a pour over will. It's set up to transfer the property. It still needs to be probated, but it may be an easier process to probate those things because it's just going to the trust and there aren't any other beneficiaries. But we do that as a catch-all. We hope not to miss anything, but there are circumstances in which someone will pass either with or without a will. And next thing you know, you're getting a knock on your door or a letter in the mail saying you've just inherited XYZ from your great uncle or someone else. So that's what the pour over will covers for those things that weren't known about, that you get back into the trust.
If I was so lucky.
Yes.
We have a hand up in Zoom. Ms. Johannes, please go ahead with your question.
Or good evening. You just alluded to part of my question because I wanted to know if you left something out of the trust, you still have to go to probate, because are you going to go to probate with just that one item that you, for whatever reason, let's say you were making a transaction and you accidentally just put it in your name instead of the trust. Do you still have to go to probate for just that one item, or will the contents that you have in the trust be dragged into the probate matter?
The last thing you said is, or will the what?
Or will the assets that you have in the trust be dragged into the probate?
No, the assets that are in the trust are owned by the trust. They are not,
Okay.
They're not going to be dragged into the probate. What you're talking about is essentially Granny's Sugar Bowl. And yes, you could end up probating Granny's Sugar Bowl because it wasn't included. That's why I tell people to put everything in the kitchen sink, take all of those pictures. It's much easier to take the pictures and say who gets what than it is to risk having to probate Granny's Sugar Bowl. Now, during your lifetime, if you get an asset and by mistake get it in your name and realize it afterwards, you can still transfer it to the trust. The problem is if you don't do it during your lifetime, and I unfortunately have had this situation where they acquired something, I didn't know they acquired it, so I couldn't do anything about it. I found out after they passed that they had acquired it, and we got to go to probate.
Okay.
That's why we say check every 5 years, go over what you have, double check, make sure everything's in there. It's a process. Now, what I will say to everybody is, if you are thinking of doing this, the best thing to do is to start putting together copies of deeds, copies of vehicle registrations, copies of account statements, insurance policies, all of the things that are the assets. Start putting that stuff together. By doing that, it also helps you realize what else you have out there. And sometimes your statements come in the mail quarterly, so you don't necessarily get them every month. And so you might forget that you have this IRA or this CD or this, fund that's with someone that you forgot about. So keep an eye out for those things.
Now, there are a couple questions that have come in. One of them is a very Caribbean question. The question is, the person indicates that they've been married to someone for a very long time, but they haven't spoken to that person for over 15 years. They don't have a will or a trust. If they were to pass, does it mean that he could inherit property?
1/3.
That her children?
Marital rights, 1/3.
Okay, so the answer is?
Right, Attorney Couture?
Attorney
Right.
Couture?
Correct. That's the
Attorney
recognized.
Couture?
Can you hear me?
Yes, I can hear you now.
That's the recognized spouse. Like if he wasn't with her for 20 years, he should have divorced her. That's his spouse.
You mean she should have divorced him?
Divorce him or what? But he could come back now, or she could come back and say, "Hey, that was my wife, that was my husband. I'm entitled to my share." Simple as that.
Marital interest.
So even though they both started living with other people, that does not matter.
They married to those other people.
What if they got married again in another country?
Repeat
No,
the
no,
question.
No. someone was asking the person get married again in another country, then that'll be bigamy. And that's against the law. You know, we're talking that this individual is still married to the first wife or the first husband. There was someone else, common law wife or shack up or what, but they're not married. So therefore, the wife, not the previous wife, the wife or the husband could come and tell the partner, the person that they live with, get out of my house.
So the first wife has priority.
Yeah.
The spouse has priority, and we do not have common law marriage in the territory. So it doesn't matter how long you live with them. If you're not married to them.
The first spouse.
So we have a question. We have a question here.
Yes, good evening. In your estimation, Ms. Marchena, do we have less or more probated properties within the enterprise zone?
I didn't expect the question to come that way. Right now, within the enterprise zone, and so I should tell everyone where the enterprise zones are on the island of St. Croix. It is the town of Christiansted. That'll be North Richmond to Gallows Bay, basically. And there's also in St. Croix, Frederiksted, which is just south of Polly Joseph Stadium, all the way to Mars Hill. And in the town of, in the island of St. Thomas, it is Garden Street and Upstreet and Savanne-Downstreet. Right now we have I think 2/3 of the properties are multiple owned. There are, I would say, 3/4 of the properties have people who are interested in them that are part or are potential heirs of those properties, are interested in trying to do something with their properties, 3/4 of them. I would say 1/4 people don't know that they own those properties, or they're singularly owned. So we have some that are active, you see them active, but they are still owned by lots of people, right? It's just that the family has decided they're going to continue and move forward with it and get it done. We are asking that those that own property within our enterprise zones step forward, even if it's one of 50 or one of 100 or one of you don't know how many own the property, step forward, contact us, because we want to move forward and fix these buildings, get them active again. I know that part of the challenge is money, right? But now suppose there was legislation that would assist in that particular regard. Would you advocate for that? I want you to email me on that one. I'm getting emails left and right. So I would really like to know if there was monies that would help you fix the property, if you were to come to an agreement with your cousins, would you advocate for that legislation? My email address, because that was one of the questions, N Marchena, which is spelled MARCHENA as in apple, at USVIEDA.org. Or you could email EZC@USVIEDA.org. Okay? So that if you were to see legislation that would assist with financing the fixing of your building, right? With the understanding that we would have to lease out that building until we could get our monies back to put into another property. Would you advocate for that as long as you could keep it within the family and as long as you could commit to working with your family members, and we could help you do that to move our community forward? That's the question. Okay?
What is the year that is considered like to be a historical building? What started in what year?
If you're building, well, there's two answers to that question. If your building is 50 years or more, right? So 50 years back or more, but in each town, the definition of what is historic is different in that in Charlton, Mali, Christiansted, and Frederiksted, the Nationally Registered District, when submitted to the federal government, looked at buildings that were Danish in structure, Danish built, right? In Cruz Bay, a historic town in the territory on the island of St. John, there's a neo-vernacular look that's different and is considered historic. So there's discussion about what people are looking at and what can become historic, etc. You could also look at something that has value, like somebody important lived there or something important happened there at that property. So there's a lot of definitions. So let's get back to probate and trust. So we talked about trust and there's two questions that came up. One is about what do you do once you've created this trust? Do you have to file it anywhere or can it be a secret document? And then the second thing is, should you put some money in there somewhere for the trustees, the successor trustees, to sort of work out the final details once you pass? Because it's not free. Maybe you need to put in some money somewhere. So what's your suggestion, Attorney Paiwanski?
So the first question again was,
oh, I forgot my first question. Let me go back to it. First question was, hold on. We'll go with the second question.
I'll
Let me
start
go
with
back
the
to-
second one.
Mhm.
Generally speaking, the trust will say that the successor trustee can be reimbursed for expenses or can use assets within the trust to pay for the things that need to be paid for. So that covers that. Another thing
But
that
if
the
those-
trust can do is it can say that the person can be compensated for their work. And it is a lot of work. Now, generally speaking, if they're a beneficiary, the argument is they're gonna benefit by getting. But if the person that you decide is not a beneficiary, there's a lot of work involved and some compensation might be dictated in the trust document to say, well, you will get this, you get compensated for your work, for the effort that you're putting in, the time and the expense and all of that.
The first question was regarding filing.
Yes, I love this question.
And then we have questions from Attorney Couture.
So the trust is a confidential document. And I generally follow the philosophy that what people don't know, don't mess with. If you don't know what you're getting, you don't try to mess with it to change anything. Your beneficiaries do not need to know what they are getting or not getting. And to save you the headache is better they don't know, so they don't try to influence you. In a lot of cases, they may not even know the trust exists until after you pass, and then they get the instructions. I find, particularly because I've seen a lot over the last 25 years of doing this, I've seen a lot of manipulations and things that happen that convince people to give to somebody before they pass certain things, or to do stuff, or to prompt, to make sure they get, this piece of property or that thing or that checking account. What if they don't know what they're going to get? And it's not theirs until it's theirs. Okay, the entire trust could be used up during your lifetime to take care of you, which is what it's supposed to be for. If there's something left over afterwards, that's what goes to them. So my preference is that it's kept confidential. You do not record it. I have had people record people's trusts and get me super upset because they record it, and there's absolutely no reason to record that secret document, but they do it, and it frustrates me, but it is confidential. And a lot of these documents have confidential information in them because we live in an age of identity fraud. And so generally what I do is if I identify a person, I'm also identifying their social security number, because there may be lots of people out there with the same name, and that person who's in charge of giving this checking account or this property to somebody wants to make sure it gets in the right hands, right social security number, right name. And so it's important that you have the details and that the people that you are trying to get your assets to get them. And so the other thing that's generally in the trust are your account numbers, because you want to specify which account so that they're not running all over the island trying to find out where this is. They need to know which account it is. But that's not information that you want out in the public. It's not their business. So it usually stays in a safe or in a secure place that they see at the end.
Okay, Attorney Couture, you had a question?
Oh, I was a comment. I was going to say, in reference to, you mentioned about the family who own different properties in the historic district. I would suggest that sometimes do a family reunion or a family tree, get to know who the players are, make contact with them, and sometimes it helps the process. Because rather than saying that, oh, this was my great-grandmother's house, you need to find out who are her children, who are their children, and go on the line. And then you go get assistance in solving some of these issues. But do a family tree, family reunion, and that does make sense.
It is an exceptional suggestion. In the BVI right now, they're getting ready to have an event in July called Homegoing or Going Home or something like that. I would suggest that we in the US Virgin Islands, the Virgin Islands of the United States, really consider that we do something like that, where we have reunions, families come home, let's talk about it, have some family historians put together those trees, make sure they get documentation, because the other day I was working on a genealogy for someone and it found that in the probated documents, they had used fragments of a church record and the fragment was off by one line. It disinherited an individual. Is that now something that could be changed? So my question is to both attorneys. If you have an error in something like that, can it be changed after the fact and redesigned after?
Well, you mean like the probate is finalized, a final adjudication was issued, you could do an amended petition, a petition to amend the final adjudication. So, but then the question would be, if the properties were distributed to, say it was like 4 years, and they got the interest money, they might decide, you know something, I'm not gonna share it with my long lost cousin, but it could be amended. You could file a petition to amend the probate. Sometimes a property might not have been included in the original probate. So we needed to add the property, whether it be a vehicle or real property, and then it'll be reinvested into the heirs. When I do a probate, I ask my clients to gather as much information as possible in terms of the assets of the decedent, check the mail, see if they're getting any bills, any statements, check the record of deeds, the tax office to see what property they own, the vehicles. Then in addition, we ask them to list the family, basically the heirs, the siblings, the children of siblings who have predeceased, and then we go from there.
Thank you. Another question came in. As we continue, as we may have momentarily lost St. Thomas, if the trust is fully confidential and someone passes, how will anyone know there is a trust? And what if that deceased has outlived their lawyer?
What happened is that with a trust, the person will name a successor trustee. And the person who did the trust, he or she is the initial trustee. Then they will name a successor trustee. Sometimes they name like 2 successor trustees. That successor trustee doesn't have to be the attorney. That could be a friend or a banker or somebody else, and that person, he or she will be in charge of carrying out the person wishes.
Thank you. Another question we have in the chat. Are your bank account proceeds subjected to the probate process if they're held jointly with relatives after you die?
Okay, so that's a good question, and it depends on which bank you're dealing with. Some bank might say, okay, it was an annual account, therefore you share the proceeds with this individual, whether it's your spouse or a child, so therefore we'll give the money to that individual. Another bank might say, no, you need to do a probate. So it depends on the bank that you're dealing with. I got some questions from St. Croix. And one is, do my beneficiaries pay tax on my property if I live here for 10, 15 years when I'm born here? There's no transfer tax for the probate. No, don't that tax in the VI. Can I sell a property that is in the name of a trust? Yes, you can. Sign a deed, your name as individually and as trustee of name of your trust. Can I get a loan mortgage on the property that is paid off, but in a trust? That'll be up to the your banker, or basically the loan. The bank might want you to take the property out of the trust so you could get a loan on it, so they could put a lien on it. But that's, as I said, that's up to your bank. Another one, the deed is the deed to the property put into the name of the trust. Yeah, so for example, if you own number 50 Rattan and your name is Louise Smith, and the trust is the local trust agreement of Louise Smith. When you buy the property, you buy the property as Louise Smith with trust dated or whatever the date is. So as Attorney Frank was saying, when you buy property, you transfer the property into your trust. So you buy it as the name of the trust. You understand?
Name the trust something different from your name. Like I discussed.
You know, into talking like a LLC or you want a business or something. Basically, you prefer to have the name, like the person name in the trust or the initials or something of that nature. Okay.
Another question we have, what is the difference between a deed of gift, a deed or gift, a deed with property held as jointly as tenants in common, and deed with language stating property is held as tenants by the entirety?
Tenants by entirety is between a husband and wife. So that it has to be between a husband and wife. And that basically says that when one spouse dies, the remainder goes to the other spouse. So husband and wife buy property 31 Rattan as tenants by entirety, husband and wife. When the husband dies, the wife will just report the husband death certificate, the property is hers. Tenants in common means that you and another person own undivided interest in a property. What happened is that, say if it's two individuals, so therefore one has 50% and the other one has another 50%. So if one person dies, his or her 50% goes to his estate or her estate, but it doesn't go to the other owner estate. Understand? And then it's probate.
Another question came in. If you have a husband and wife with one child, do you need one trust or two, and both are Virgin Islanders?
I know that actually you want to answer that, but basically you could do one trust. Say the husband is Raymond Smith. He will say that the Smith family trust, and you could just use one trust.
And this one may have been answered already, so please excuse me. If someone dies with joint bank accounts with their spouse, is that a probate asset or is that right of survivorship?
It depends on how it's held. And as I said before, it depends on the bank too. Some bank might say, okay, it was jointly held and it had it with the right of survivorship, therefore the surviving spouse would get the money. Another bank might say, no, we need to have a probate open and go to the probate process. So that would be a question that the individual had to talk to his or her bank.
That was asked was, if the person who created the trust begins to have some condition that that makes them lack capacity, whether it's beginning of Alzheimer's or dementia, whatever it is, what happens, what can take place so that they don't start making decisions and either transferring assets to caregivers or the guy on the street or somebody who comes to visit. The answer is you get a medical, a letter from the doctor verifying that the person is incapacitated. And at that point, the successor trustee then steps in their place so that they can take care of them during their lifetime.
Okay. What is the difference between a deed of gift? A deed with language stating property is held as tenants by entirety. A deed with property held as tenants in common.
So a deed of gift is a transfer as a gift. So from one person to another as a gift. If it's a family member, it's generally exempt from stamp tax. So that's just a straight transfer. A deed that is in the entirety, generally is in the entirety with right of survivorship, which means that if one of the owners passes, the next one, the surviving person, becomes the sole owner. So in the case of a husband and wife owning property by the entirety, it means that if one of the spouse passes, the surviving spouse owns that property outright. Property held in common are two individuals who own property together in common. And if one of them passes, their interest goes to whomever they decide by a will or through probate, whoever their heirs are, it would go to their 50% ownership interest would stay within their, whoever they transfer it to by trust or by will or by probate. And the other person's 50% likewise would go through that same process. In other words, it doesn't mean that the survivor of the two gets it. It stays within whoever they decide to transfer it.
I think that's what Attorney Couture just answered on that side of the water. One of the questions, another question that has come in, what is the first thing one must do to prepare to meet an attorney when dealing with a will? And then what's the first thing that they must prepare to deal with an attorney doing a trust? So I'm going to defer to Attorney Couture.
With a trust or a will, when I meet with my potential clients, I try to find out what they want to accomplish. Because I was what the client wants. Explain them the pros and cons of a will, the pros and cons of a trust. But basically, I would need to know his or her, the family makeup, the assets, the obligations, and then we would draft the document accordingly to the wishes for the properties. So, for example, they want to do a trust. I want to know who's going to be the beneficiary of a particular property. And in addition, the alternative, in case that person dies before. Then I know Attorney Pranwasi mentioned about the power attorneys who would this individual want to serve as the power attorney, whether for medical or financial. And it just goes on and on. I give my clients a checklist or maybe like 10 pages. And basically I tell them to go and just think about what if my child dies before me? Who should get a property? Or should I leave the property to have him get it at 18 versus 35? Who should make the decision as to when my child should get the full bulk of the money, whether it's a portion at 25, the remaining at 35. You know? I had a question on St. Croix, and it was, how can they tell how the deed is held? But it's by tenants, by the joint rights of survivorship, tenants by the entirety, or tenants in common. Basically, in the middle of the deed, it will say, if it's husband and wife, it will say husband and wife by tenants by entirety. If it's held by joint rights of survivorship, it will say joint rights of survivorship. Tenants in common, it will say in fee simple. So it all be stated on the particular deed. And then the other question was, okay, I guess answer both in the will and the trust. So I know Attorney Pranwasi can add some more comments to it.
I think for both the will and a trust, you're going to want to go to the attorney with paperwork in terms of what assets you have, as Attorney Couture said, with who are the people who are going to be beneficiaries, and make the decisions in terms of who's going to make these decisions for you. I think for most people, the hardest thing is who is going to make the decisions for me on medical care and for my trust, if I have one, who's going to be making the decisions for me in terms of what's going to happen to me in my care. And I think those are the really difficult ones, particularly, a lot of the younger generation have moved off island. So it's not like you can depend on your children to look after you. So you're looking to other people possibly other than family members, because you may not have them physically here to make some of those decisions. Some things can be decided long distance. We're in the technological age with all of these things at your disposal, that it is possible for people who are somewhere else to make decisions for you. It becomes a little bit more challenging when we're talking about somebody at a hospital or at a doctor's office trying to make a decision about a procedure or what should be done. And so think about those issues, those concerns, because obviously you want what's best for you, and people who are too far away may not have all of the pieces to make the best decision.
So we have a question with regard to what's the legal amount of money should you put in a will for a person that you don't want to inherit anything? They want to disown their child, or they want to disown their husband. but they want to put some money in that will, whether it be $1, $10, whatever the legal amount is, in order for them not to be able to challenge that will. Attorney Couture, this is the question that is before us. What is the legal, I'm promising you, I'm reading it. What is the legal amount to put in a will for a person who should not be entitled to anything?
See what happened? Some put a nominal amount, whether $1, $10, or $100. What you should note, a spouse can challenge a will and say, even though my wife left a will saying that I'm not going to get anything, I'm going to challenge it, and I demand my spousal right, which is 1/3. So,
thank you for that answer. An Attorney Couture is as straight up as you can get, right? He has indicated to you that there's no legal amount that you could, Attorney Couture, would you agree that a will is instructions for the judge?
Right.
And a trust. Go ahead.
The good thing about a trust is that the trust is like your blueprint for the successful trustee to follow your directions. Whereas the will is a blueprint, however, is for the court to interpret, and the court to say, you know something, the spouse has a right to 1/3, so therefore I'm going to give the spouse 1/3. This child was able to prove that his or her mother was coerced or unduly influenced, so therefore I'm going to include this child in the inheritance. So therefore, with a trust, what you want, you get it basically at the end. Whereas with a will, it's up to court interpretation. So it's no guarantee that your wishes will be fulfilled.
The other thing that I'd like to mention with respect to this is that in some cases you can put into a will, if you contest this, then you get X. You either get nothing or you get $1. And it is the mechanism by which you try to avoid having people contest the will by saying, you can fight this, I'm giving you $10, but if you decide to fight this, you're going to get $1.
When the will is submitted to probate, then you will contest it.
Okay.
Now, one of the things that I do want to mention, this may not apply to the people on Zoom or in the audiences, but if you have minor children or minor beneficiaries, what Attorney Couture was talking about earlier about the distribution and at what age, if you have minor children or grandchildren who are going to be beneficiaries and they have not reached the age of adulthood, then you may want to include in that document in the trust that the person be cared for and that their education be paid for while they're in school, including college or vocational training up to a certain age. And then what you're trying to do is you're trying to wait before the trustee has to give them money that they're not quite mature enough to handle. And so for minor children, it is possible to stagger the distributions based on their age. Some people are very, very good managing money, so you may be less concerned. 25 may be a suitable age. But some people, money just burns a hole in their pocket and you want to stagger it out and have them receive distributions on a monthly basis up until a certain age so that they can hopefully learn how to properly manage those benefits.
Wow. It has been a really interesting discussion this evening. I want to give both of our attorneys a chance to give one last piece of advice that really is the most critical thing you can tell an individual today. And I'm going to start with Attorney Paiwanski.
As difficult as it is to think about some of these concepts that we're talking about today, it is significantly better for you to make these decisions during your lifetime than to leave it up to a probate court without a will or without a trust. Some of these decisions are hard. Some people don't necessarily want to think about these things. I've had people take months to tell me where they want to be buried and whether or not they want to be cremated. Months, because they just don't want to think about these things. But it is better for you to take charge of these things during your lifetime while you have the capacity to do so, as opposed to them being made for you and for your beneficiaries. Thank you.
Thank you. Attorney Couture?
What I would say is that the important thing is for you, the individual, to be comfortable in knowing that your wishes will be adhered to. You might upset a relative, a child, but so what, you'll be dead. What are they going to do? You know, are they going to come and stamp on your grave? Whatever. The important thing is for you to be comfortable to know that your asset, the care of your minor children, etc., is taken care of according to your wishes. So the most important thing is to be reflective, to plan and do it. It's nice to say, oh, I'd like to get a trust or do a will. The important thing is to start the process and complete the process. As Attorney Paiwanski said, you need to fund the trust, meaning transfer the properties to the trust. So just, as Nike said, just do it.
I want to really thank both Attorney Couture and Attorney Paiwanski for their information tonight. It has been, and we've been all over the map on estate planning tonight. I think that as much, and I know as much as many questions as they answered, there are 5 times the amount of questions that came in that we were not able to get to. I've already been asked to do another one of these particular conferences. And we will think about that as we are stepping forward to do a couple other things, which is to work with 8 pilot families within the territory, using the same grant to work with those families to create sort of a template for how you can move forward in resolving these issues. I have a pet peeve, and my pet peeve is, as much as you come and you listen to this information, you go home tonight, you say, I have to do something, I'll do it tomorrow. And then life gets in the way and you don't do it. I'm asking all the people on Facebook, all the people on Zoom, the people on listening to the radio and TV, the persons in the St. Croix site and the St. Thomas site, please, please, please do something. Take out a piece of paper, a blank piece of paper, and put a line down the center and put all the assets, including Granny Sugar Bowl, all your assets. I'm gonna tell you, my grandmother put in books. It may have seemed like nothing to certain people, but to me, She was a librarian. To me, these books meant the world. So it might not be something that's worth something to someone else, but there might be a child that just wants Granny's old brush and her comb, right? So don't think of your assets as only the house or the property or the antique car. I want you to think about your individuals. Think about the individuals that you would like to give to. Write their names down on the right-hand side, or the left-hand side rather, and then write all your assets and what you're giving to them. And just draw the line, right? You've been given information tonight that says, don't take one building with 2 rooms in it and split it amongst your 5 children. Because basically what you're saying is, let them fight over it. So please do something. Take out that piece of paper, get that together. Do something. I want to thank not only the attorneys, I'd like to thank the Department of Interior. I'd like to thank my team as they are throughout the territory tonight. I'd like to thank Simple Marketing, Government Access Channel. They will replay and repeat this. The Vibe, and the attendees for all that you have done. You've spent the evening with us. I would like to give my contact information again. If you have a question about, and we're going to send out contact information and the slides to you, should you email us for that. The email is ezc@usvieda.org. I'm going to repeat that. E as in echo, Z as in zebra, C as in cacciatore, at usvieda.org. Send your emails in. We'd like to know your thoughts. We also asked you if you're interested in a piece of legislation that will do something like that and retain property for the people of the Virgin Islands and avoid gentrification. Are you interested in supporting something like that? Because we need to move. We need to revitalize our towns and move forward. On behalf of the Virgin Islands Economic Development Authority, the Enterprise Zone Commission, the Board of Directors, and the team, we thank you for attending this evening. Good night.